भूमिका व्यक्ति निर्माण की होती है और व्यक्ति निर्माण से ही राष्ट्र निर्माण होता है। और आज जिस कालखंड में भारत है, उसमें व्यक्ति निर्माण का अभियान बहुत ज्यादा अहम हो गया है। मैं आप सभी को वॉइस ऑफ यूथ वर्कशॉप की सफलता के लिए अग्रिम शुभकामनाएं देता हूं। साथियों, हर देश को इतिहास एक ऐसा कालखंड देता है जब वो अपनी विकास यात्रा को कई गुना आगे बढ़ा लेता है। ये एक तरह से उस देश का अमृतकाल होता है। भारत के लिए ये अमृतकाल इसी समय आया है। ये भारत के इतिहास का वो कालखंड है जब देश एक क्वांटम जंप लगाने जा रहा है। हमारे इर्द गिर्द ही ऐसे अनेक देशों के उदाहरण हैं जिन्होंने एक तय समय में ऐसा ही क्वांटम जंप लेकर खुद को विकसित बना लिया। इसलिए ही मैं कहता हूं, भारत के लिए भी यही समय है, सही समय है।
महाकोश, कच्ची घानी सरसों तेल और रिफाइंड सोयाबीन ऑयल, चुनो सही।
जम्मू कश्मीर में आर्टिकल 370 पर कुछ ही देर में आएगा सुप्रीम कोर्ट का फैसला। 5 जजों की संविधान पीठ आर्टिकल 370 की वैधता पर सुनाएगी फैसला। जम्मू कश्मीर में सुरक्षा के पुख्ता इंतजाम। छत्तीसगढ़ के नए सीएम होंगे विष्णुदेव साय। अरुण साव और विजय शर्मा होंगे डिप्टी सीएम। 13 दिसंबर को शपथ ग्रहण। पूर्व सीएम रमन सिंह बनेंगे विधानसभा अध्यक्ष। आज तय होगा मध्य प्रदेश का मुख्यमंत्री। भोपाल में होगी बीजेपी विधायक दल की बैठक। कैलाश विजयवर्गीय ने की शिवराज सिंह चौहान से मुलाकात। राजस्थान में मंगलवार को चुना जाएगा विधायक दल का नेता। आज शाम जयपुर पहुंच सकते हैं पर्यवेक्षक राजनाथ सिंह। कांग्रेस सांसद धीरज साहू के 3 राज्यों में मौजूद ठिकानों पर छापे लगातार जारी। आईटी ने अब तक 351 करोड़ कैश किया बरामद। बीजेपी अध्यक्ष जेपी नड्डा की अगुवाई में पार्टी सांसदों का कांग्रेस के खिलाफ संबोधन। प्रधानमंत्री नरेंद्र मोदी ने विकसित भारत 2047 का किया शुभारंभ। 700 विश्वविद्यालयों के कुलपति और संस्थानों के प्रमुख थे मौजूद।
महाकोश, कच्ची घानी सरसों तेल और रिफाइंड सोयाबीन ऑयल, चुनो सही।
और एक बड़ी खबर इस वक्त की। आर्टिकल 370 पर सुप्रीम कोर्ट का फैसला बस आने ही वाला है और उससे पहले जम्मू कश्मीर के उपराज्यपाल मनोज सिन्हा ने दिया है एक बड़ा बयान। मनोज सिन्हा ने कहा है कि कोई भी जम्मू कश्मीर में नजरबंद नहीं है। मनोज सिन्हा ने लोगों से अफवाहों पर ध्यान न देने की भी अपील की है। ऐसे में जबकि बस फैसला आने ही वाला है, एलजी मनोज सिन्हा ने साफ कर दिया है कि अफवाह फैलाने की कोशिश की जा रही है जिस पर ध्यान ना दिया जाए, क्योंकि जम्मू कश्मीर में किसी को भी नजरबंद नहीं किया गया है। अफवाह यह फैलाई जाने की भी आशंका कि यह सुप्रीम कोर्ट का फैसला आने से पहले क्या कुछ लोगों को नजरबंद कर दिया गया। ऐसे में एलजी ने इससे साफ इनकार किया।
ये पूरी तरह से निराधार है।
more than one provision, that is the entire part of the Constitution. The provision does not make a distinction between one that is the entire Constitution. The provision does not make a distinction between one or all merely because CO 272. Non-application of all cannot be claimed merely because CO 272 applies all provisions of the Constitution. Is the challenge to CO 272 on the grounds that the President could not have secured the concurrence of the Union government under the second proviso to Article 370. Not have secured the concurrence of the Union government. We hold under the second proviso to Article seeking the concurrence of the Union government. Instead of the government of the state, the President seeking the concurrence of the Union government is not instead of the government of the state first issue CO 272 of applying all the provisions of the Constitution because to the state of Jammu and Kashmir, the effect of applying all the provisions under Article 370 to the state of Jammu and Kashmir is the same as an exercise of power under Article 370 Clause 3 is the same as an exercise of power under Article 370. That is, all provisions of the Constitution of India will apply to the state of Jammu and Kashmir. All provisions of the Constitution of that the former can be reversed to the state of Jammu and Kashmir under Clause 3 except for the fact that the former can be reversed while the collaboration between both the units will only be necessary with the application and collaboration between both the units will only be necessary would require amendment the Indian Constitution because the purpose of the requirements of would require amendments to the state constitution is for the smooth functioning of governance in the requirements of consultation and to ensure that the provisions of the Constitution of Jammu and Kashmir are not inconsistent. And to ensure that the provisions of the Constitution of Jammu and Kashmir are not inconsistent. Since the effect of applying all the provisions of the Constitution of Jammu and Kashmir, since the effect of applying all the provisions of the Constitution of Jammu and Kashmir to Jammu and Kashmir, since the effect of applying all the provisions of the Constitution to Jammu and Kashmir is the same as the exercise of the power under Article 370 Clause 1D, which the President has the power to unilaterally under Article 370 of consultation and collaboration, which the President has the power to unilaterally issue. Fourth, the principle of consultation and collaboration malafide only if power was exercised with an intent to deceive. The exercise of power is malafide only be proved if power was exercised which is otherwise unavailable to the authority or body. Deception can only be exercised if the power which is otherwise unavailable to the authority or body is exercised. The concurrence of the or if the power that is available was not required for the exercise of power under Article 370 bracket 1 bracket D was not required for the exercise of power under Article 370 bracket 1 President securing the concurrence of the Union of India on behalf of the state government is not malafide. The President securing the concurrence of the Union of India. The next issue is on the challenge to state government to CO 272 on the ground that it is ultra-vires the challenge to CO 272 because it modifies that it is ultra-vires Article 370 1D. We have held because it modifies that the modification by CO 272 we have Article 367 that the modification as it applies to Jammu and Kashmir had the effect of amending Article 370 as it applies to Jammu and Kashmir Article 370 of amending Article 370. We have reached this conclusion for the following Article 370 bracket 1D. Recourse must be had to this conclusion for the following by Article 370 Clause 3. Recourse if Article 370 is to cease to operate by Article 370 amended or modified if Article 370 is to cease to operate. No other procedure or modified utilized to amend the state of Jammu and Kashmir. Second, no other procedure. The rule of interpretation utilized to amend power under a statute must be exercised in accordance with the rule of interpretation that the power under the statute is undoubtedly in accordance with the provisions of that statute. Third, and in no other manner is undoubtedly applicable to the Constitution. Sajjan Singh, Quixote Holohan, and Rajendra Shah, Shankari Prasad it emerges that the following aspects of significance and Rajendra Shah whether a change is made to a provision of the following aspects are of significance when assessing whether either in terms of a provision of the Constitution. 1. A change can be said either in terms of the language of the concerned provision is not directly amended. A change can be said to have been made even if the language of the concerned provision is not directly amended. And by adding, subtracting, the effect of an amendment is to change a provision. Such effect must be significant or appreciable. If the effect of an amendment is to change a provision, such effect must be significant or appreciable. And 4. Second, the substance of a change is more important than its form. Amounts to a modification. And consequently, whether the procedure under Article 370 amounts to a modification, or under Article 370 whether the procedure under Article 370 depends on this standard, or under Article 370 the effect of a provision of law is as important as its form. Third, while the change sought to be made by paragraph is as important as its form, may appear to be a modification or amendment of Article 367 at first blush. may appear to be a modification or amendment of Article 367 at first blush. Its effect is to amend
changes the language to the proviso to
Article 370
CO
clause 3 in 2 ways.
changes the language
First,
to the proviso
it
to
changes
Article
the recommending
370
body
clause
from
3
the
in 2
Constituent
ways.
Assembly to the Legislative
First,
Assembly.
It changes
And
the
second,
recommending body
it
from the
makes a new
Constituent
arrangement
Assembly
at
to the
variance
Legislative
with
Assembly.
that specific Constituent
second,
Assembly.
it makes a new
Both these
arrangement
changes
at
are not
variance
insignificant.
with that specific
because they
Constituent
modify the
Assembly.
essential character of the
Both these
proviso
changes are
by
not
substituting a
insignificant
particular type
because
or
they
kind of
modify
body
the essential
with
character
another
of the
type or
proviso
kind entirely. By substituting a
Fourth,
particular type or
while
kind
the
of body
interpretation clause,
with another
namely
type
Article
or kind
367,
entirely can be
Fourth,
used to define
while
or
the
give meaning to
interpretation
particular
clause,
terms,
namely Article
it
367,
cannot be deployed
can be used
to
to
amend
define
a
or
provision
give meaning to
by
particular
bypassing
terms.
the specific
It
procedure
cannot
laid
be
down for its
deployed
amendment.
to amend a provision
This would defeat the
by
purpose
bypassing
of having
the
a procedure
laid
or making
down
an
for its
amendment to the
amendment.
Constitution of India.
This
This would defeat the purpose of having a consequence of permitting amendment to the Constitution of India. The circuitous manner would be disastrous. The consequence of permitting amendment to the Constitution to the circuitous manner would be disastrous.
Which evade the procedure
Many
stipulated
provisions
by
of the
Article
Constitution would
368
be
or other
susceptible to
provisions,
amendments, which
evade
evade
the procedure stipulated
the
by
previous
Article
constitutional
368
orders or other
which
provisions.
modified Article 370 through
The
Article
previous
367
constitutional orders
were
were
clarificatory
clarificatory
Article
and
370
consequential.
through
They
Article
did not have the
367
effect
of
were
amending
clarificatory
Article
and
370.
consequential.
We have therefore
They did not
held as
have the
ultra
effect
of amending Article
the amendments
370.
which were made
We
to
have therefore
Article 370
held as
clause
ultra
3 by taking recourse to Article
the amendments which
367.
were made to Article 370
G.
clause 3
The
by
status
taking
of
recourse to Article
the Constitution of
367.
Jammu and Kashmir.
G.
The gaps
The
left by
status
the
of
non-application
the
of some
Constitution
parts
of
of the
Jammu and
Constitution
Kashmir.
of India,
The
were
gaps
filled
left
by the
Constitution
non-application of some parts of the Constitution of India
after the abrogation
were
of Article
filled by the
370
Constitution of the state
as it stood before the issuance
after
of
the
CO272
abrogation of Article 370
and the
as it
application
stood
of the
before the
entirety of the
issuance of
Constitution of India to
CO272
the
and
state.
CO273.
The Constitution of the
And the
state
application of the
does not
entirety of the
fulfill any
Constitution of
purpose
India to
or
the state.
serve any function.
The Constitution of the
Hence,
state
the
does
implicit
not
but
fulfill
necessary
any consequence
purpose or
of the
serve
application
any
of the
function.
Constitution of India.
Hence,
In its
the
entirety
implicit
to the
but
state of
necessary
Jammu and
consequence
Kashmir
of the application
is that
of
the
the Constitution
Constitution
of
of the
India
state in its
is
entirety to the
inoperative.
state of Jammu and Kashmir is that
On
the
the validity
Constitution of the state
of Parliament's
is
exercise
inoperative.
of power
Under the first proviso
On the
to
validity
Article 3 of Parliament's
what we have
exercise
said.
of power under the
A
first
five-judge
proviso
bench
to
of this
Article
court
3,
in Babulal Parate
this is what we have
held
said, that the views expressed by the
five-judge bench of
legislature
this court
of the
in
state
Babulal Parate
under the
held
proviso to Article
that the
3
views
are not
expressed
binding
by
on
the
the
Parliament.
legislature of the state.
If the views of the
under
state
the proviso to
legislature
Article
were
3
binding
are
on
not
Parliament,
binding on
which is
Parliament,
not the case,
if the views
there would
of
be
the state
scope
for debate on whether
were
Parliament
binding
in
on
exercise
Parliament,
of its
which is
powers
not
under
the
Article
case,
356
there would be
1B
scope for debate on
would have
whether
substituted
Parliament
in
in
exercise of
for
its
the views
powers
of the
under Article
Legislative Assembly of the
356
state.
1B.
However,
Would have substituted
the
its
views of the
views
legislature
for
of
the
the
views of the
state are not
Legislative
binding
Assembly
on
of the
Parliament
state.
in terms of the first
However,
proviso to
the
Article
views
3.
of the legislature of the
The
state
views
are
of the
not
legislature
binding
of
on
the state
Parliament
under
in
the
terms
first
of the
proviso
first
to
proviso
Article
to
3
Article
are
3.
recommendatory.
The views
to
of the
begin with.
legislature of the state
As
under the
Parliament's
first
exercise
proviso
of
to
power
Article
under the
3
first
are
proviso to
recommendatory
Article 3 is
to
valid
begin with
and not
As
malafide.
Parliament's exercise
The
of
next
power under
issue
the first
is
proviso
on the
to Article
validity
3 is valid
of the
and not
suspension
malafide. Of the second proviso
The next
to Article
issue
3
is
as
on the
applicable to
validity
Jammu and Kashmir.
of the suspension
Of the
when the
second proviso to
reorganization bill
Article
was
3
introduced,
as
that is on
applicable to
5
Jammu and
August
Kashmir.
2019, when the
The second
reorganization
proviso
bill
to
was
Article
introduced,
3
that is
as
on
it
5
applied to the
August
state of Jammu and
2019,
Kashmir,
ceased
the
to
second
exist
proviso
because
to
of
Article
CO
3
272.
as it applied to the state
Thus,
of
the
Jammu and
issue of
Kashmir
whether the second proviso
ceased
to
to exist
Article
because
3
of CO
CO 272
in exercise
Thus,
of the
the
power
issue
under
of whether
Article
the second proviso to
356
Article
1C
3
does not
could have been
survive.
suspended.
In exercise
The
of the
next
power
issue
under Article
is the validity
356
of the
1C
Jammu
does
and
not
Kashmir
survive.
Reorganization Act 2019.
The next issue is the validity of the
The
Jammu and
Solicitor
Kashmir
General,
Reorganization
appearing for
Act
the Union of India,
2019 submitted
that
the
statehood
Solicitor
will be
General
restored to Jammu and
appearing
Kashmir
for the Union of India
and that its status as a,
submitted
as
that
a
statehood
union territory
will be restored
is
to Jammu and
temporary.
Kashmir
The
and that its
Solicitor General
status as a,
submitted
as a
that the
union
status
territory
of the Union
is
Territory of
temporary.
Ladakh
will not be affected
The
by the
Solicitor General
restoration of
submitted
statehood to
that
Jammu
the
and
status
Kashmir.
of the Union Territory of
In
Ladakh
view
will
of the
not be
submission
affected
made
by
by the Solicitor
restoration
General
of statehood to
that
Jammu and
statehood
Kashmir.
would be restored
In
of
view
Jammu
of
and
the
Kashmir.
submission made by the
We do
Solicitor
not
General
find it necessary to
that
determine
statehood would be
whether
restored
the
of Jammu and
reorganization of the
Kashmir
state of Jammu
we
and
do
do not
Kashmir
find it necessary
into
to
two union
determine
territories of
whether
Ladakh
the
and Jammu and
reorganization
Kashmir
of the
is
state of
permissible
Jammu
under
and
Article
Kashmir
3. Into two union
The
territories
status
of
of
Ladakh
Ladakh
and
as a
Jammu and
union
Kashmir
territory
is
is
permissible under
upheld
Article 3.
because
Article 3A,
the status of
read with
Ladakh as a
explanation
union
1,
territory is
permits
upheld
forming a union territory
because Article 3A
by separation of a
read with
territory from any
explanation
state.
1
Permits forming a union
This court
territory
is
by
alive to the
separation of a
security
territory from
concerns
any
in the
state.
territory.
Direct
court
elections
is
to the
alive to
legislative
the security
assemblies,
concerns
which is
in
one
the
of the
territory.
paramount features of representative
Direct elections
democracy
to
in
the
India,
legislative assemblies,
cannot be put
which
on
is one of
hold
the paramount
until
features of
statehood is
representative
restored.
democracy in India.
We
cannot
direct
be put on
that
hold
steps shall be
until
taken by the
statehood is
Election
restored.
Commission of India
to conduct elections to the legislative assembly of Jammu and Kashmir, Election Commission of India, constituted under Section 14 of the Reorganization Act by 30 September 2024, constituted under Section 14 of the Reorganization Act by 30 September 2024, and as soon as possible. Restoration of statehood. The question of whether Parliament can extinguish the character of statehood by converting a state into one or more union territories, the character of exercise of power under by converting a state into one or more union territories. In an appropriate case, exercise of power must construe the scope of powers under Article 3. In an appropriate case, the necessary effect this court must converting a scope of powers under Article 3, which is that autonomy would be diminished of converting a state historical context for the creation of federating autonomy would be diminished, and its impact on the principles of federalism, historical context for the creation of federating democracy, and its impact on the principles of federalism. In view of the above discussion, the following are the conclusions. In view of the above discussion, the state of Jammu and Kashmir are the conclusions. Does not retain any element of sovereignty. The state of Jammu and Kashmir of the instrument of does not retain any element of sovereignty. The proclamation after the 25 November 1949 and the issuance by which the proclamation of India was adopted November 1949. The state of Jammu and Kashmir does by which the Constitution of India was adopted, which is distinguishable from the powers and privileges does not have enjoyed by other states in the country, which is distinguishable from the powers and privileges was a feature enjoyed by other states federalism and not sovereignty. Article 370 was a feature of asymmetric federalism. Did not challenge the issuance of the proclamations under Section 92 of the Jammu and Kashmir Constitution. Did not challenge the issuance of the proclamations under Section 92 of the Jammu and Kashmir Constitution. The special status of Jammu and Kashmir was abrogated. Indian Constitution. The challenge to the proclamations does not merit Jammu and Kashmir was abrogated. Because the principal challenge to the proclamations does not merit the proclamation was issued. Because the principal challenge is to the exercise of power by the President after the proclamation under Article 356 is issued. The exercise of power by the judicial review after the proclamation. The exercise of power by the President issued must have a reasonable nexus with the object of the proclamation. The exercise of power by the person challenging the exercise of power must prima facie establish the proclamation that it is a mala fide or extraneous exercise of power must prima facie establish. Once a prima facie case is made, that it is a mala fide or extraneous exercise to justify the exercise of such power. Once a prima facie case is made, the ownership of the Parliament under Article 356 1B to exercise the powers of the legislature of Parliament under Article 356 cannot be restricted to exercise the powers of the legislature of the state, thereby excluding cannot be non-lawmaking power of the legislature to lawmaking power. Such an interpretation would amount to reading and limitation into the provision contrary to the text of the article. Such an interpretation would amount to reading and limitation from the historical context for the inclusion of Article 370 Kashmir. It can be garnered from the historical context for the inclusion of Article 370 have been taken during the present temporary provision 370 in Part 2 F21. Even if the power under Article 370 it is a temporary provision did not cease to exist upon the dissolution of the Constituent Assembly of Jammu and Kashmir did not cease to exist. The Constituent Assembly was dissolved. The Constituent Assembly of Jammu and Kashmir recognized in the Constituent Assembly was dissolved. Only the transition empowered the Constituent Assembly to make a Constituent Assembly, thereby excluding non-lawmaking powers of the legislature of the state. Into two union territories of Ladakh and Jammu and Kashmir is permissible under Article 370. The status of Ladakh as a union territory is upheld because Article 3A, read with explanation 1, permits forming a union territory by separation of a territory from any state. This court is alive to the security concerns in the territory. Direct elections to the legislative assemblies, which is one of the paramount features of representative democracy in India, cannot be put on hold until statehood is restored. We direct that steps shall be taken by the Election Commission of India to conduct elections to the Legislative Assembly of Jammu and Kashmir, constituted under Section 14 of the Reorganization Act by 30 September 2024. Restoration of statehood shall take place at the earliest and as soon as possible. The question of whether Parliament can extinguish the character of statehood by converting a state into one or more union territories in exercise of power under Article 3 is left open. In an appropriate case, this court must construe the scope of powers under Article 3 in light of the necessary effect of converting a state into union territories, which is that autonomy would be diminished, the historical context for the creation of federating units, and its impact on the principles of federalism and representative democracy. In view of the above discussion, the following are the conclusions. A. The state of Jammu and Kashmir does not retain any element of sovereignty after the execution of the instrument of accession and the issuance of the proclamation declaration dated 25 November 1949, by which the Constitution of India was adopted. The state of Jammu and Kashmir does not have internal sovereignty, which is distinguishable from the powers and privileges enjoyed by other states in the country. Article 370 was a feature of asymmetric federalism and not sovereignty. B. The petitioners did not challenge the issuance of the proclamations under Section 92 of the Jammu and Kashmir Constitution and Article 356 of the Indian Constitution until the special status of Jammu and Kashmir was abrogated. The challenge to the proclamations does not merit adjudication because the principal challenge is to the actions which were taken after the proclamation was issued. C. The exercise of power by the President after the proclamation under Article 356 is issued is subject to judicial review. The exercise of power by the President must have a reasonable nexus with the object of the proclamation. The person challenging the exercise of power must prima facie establish that it is a mala fide or extraneous exercise of power. Once a prima facie case is made, the onus shifts to the Union to justify the exercise of such power. D. The power of Parliament under Article 356(1)(b) to exercise the powers of the legislature of the state cannot be restricted to lawmaking power, thereby excluding non-lawmaking power of the legislature of the state. Such an interpretation would amount to reading in a limitation into the provision contrary to the text of the article. E. It can be garnered from the historical context for the inclusion of Article 370 and the placement of Article 370 in Part 21 of the Constitution that it is a temporary provision. F. The power under Article 370 Clause 3 did not cease to exist upon the dissolution of the Constituent Assembly of Jammu and Kashmir. When the Constituent Assembly was dissolved, only the transitional power recognized in the proviso to Article 370 Clause 3, which empowered the Constituent Assembly to make its recommendations, ceased to exist. It did not affect the power held by the President under Article 370 Clause 3. G. Article 370 cannot be amended by exercise of power under Article 370(1)(d). Recourse must have been taken to the procedure contemplated by Article 370 Clause 3 if Article 370 is to cease to operate or is to be amended or modified in its application to the state of Jammu and Kashmir. Paragraph 2 of CO 272, by which Article 370 was amended through Article 367, is ultra vires Article 370 Clause 1, Clause D, because it modifies Article 370 in effect without following the procedure prescribed to modify Article 370. An interpretation clause cannot be used to bypass the procedure laid down for amendment. H. The exercise of power by the President under Article 370(1)(d) to issue CO 272 is not mala fide. The President, in exercise of power under Article 370 Clause 3, can unilaterally issue a notification that Article 370 ceases to exist. The President did not have to secure the concurrence of the government of the state or union government acting on behalf of the state government under the second proviso to Article 370(1)(d) while applying all the provisions of the Constitution to Jammu and Kashmir, because such an exercise of power has the same effect as an exercise of power under Clause 3 of Article 370, for which the concurrence or collaboration with the state government was not required. I. Paragraph 2 of CO 272 issued by the President in exercise of power under Article 370(1)(d), applying all the provisions of the Constitution of India to the state of Jammu and Kashmir is valid. Such an exercise of power is not mala fide, merely because all the provisions were applied together without following a piecemeal approach. J. The President had the power to issue a notification declaring that Article 370 Clause 3 ceases to operate without the recommendation of the Constituent Assembly. The continuous exercise of power under Article 370 Clause 1 by the President indicates that the gradual process of constitutional integration was ongoing. The declaration issued by the President under Article 370 Clause 3 is a culmination of the process of integration and as such is a valid exercise of power. Thus, CO 273 is valid. K. The Constitution of India is a complete code for constitutional governance. Following the application of the Constitution of India in its entirety to the state of Jammu and Kashmir by CO 273, the Constitution of the State of Jammu and Kashmir is inoperative and is declared to have become redundant. Well, the views of the legislature of the state under the first proviso to Article 3 recommend AG. Thus, Parliament's exercise of power under the first proviso to Article 3 under the proclamation was valid and not malafide. M. The Solicitor General stated that the statehood of Jammu and Kashmir will be restored except for the carving out of the Union Territory of Ladakh. In view of the statement, we do not find it necessary to determine would require whether the reorganization of the state of Jammu and Kashmir into two Union Territories of Ladakh and Jammu and Kashmir is permissible under Article 3. However, we uphold the validity of the decision because carve out the Union Territory of Ladakh in view of Article 3A, read with explanation 1, which permits forming a Union Territory by separation of a territory from any state. And we direct that steps shall be taken by the Election Commission of India to conduct elections to the Legislative Assembly of Jammu and Kashmir, constituted under Section 14 of the Reorganization Act by 30 September 2024. Restoration of statehood shall take place at the earliest and as soon as possible.
Ongoing exercise long after the fulfillment of the first assembly was dissolved. Second purpose remains an ongoing exercise long after the state of the requirements of a recommendation from the conditionality in article cannot be read in the manner of the requirement of a larger intention of the assembly cannot be read in the manner as to make the reference to the larger intention.
सुप्रीम कोर्ट ने 370 के निरस्त करने के फैसले को संवैधानिक ठहराया है। साथ ही साथ इलेक्शन कमीशन को आदेश भी दिए हैं कि जम्मू कश्मीर में जल्द से जल्द विधानसभा के चुनाव कराए जाएं। तारीख उन्होंने मुकर्रर की है 30 सितंबर 2024 से पहले जम्मू कश्मीर में विधानसभा के चुनाव कराए जाएं। स्टेटहुड जितने जल्दी पॉसिबल हो उतने जल्दी
The main provision is the proviso power to issue a declaration became continuous to exist. The main provision, which is the president's power to issue a declaration, first the amendment of Article 373 through the route of Article 367 action, first the amendment of Article 370 methodology has been provided that 367 will have to be followed invalid, and when a methodology has been provided that methodology would have to be followed. Concurrence with the government amendment of the state was not necessary to apply all provisions of the Constitution. Concurrence with the government of the state was although Article to apply all provisions requires concurrence with the government of the state. In this case, the governor of the state had dissolved the legislative government of the state. In this case, the governor of the state had dissolved the legislative assembly of the state. All functions there were no council of ministers, and the president had resumed 2018 proclamation. All functions of the government of the state. Then on the exercise of power under Article 2018 proclamation were permissible while issuing. Then on the exercise of power under Article 356 were permissible while Article 356 can be imposed once the legislative assembly has been dissolved. Article 356 section 92 of the Jammu Legislative Assembly has been dissolved. Limited the governor's role to 6 months without 92 of the Jammu and Kashmir Constitution. Positions were limited the governor's role to 6 months without any scope to extend, which really took place prior to the government. Predicated on the failure of the Constitution. Then B. Article 356 really took place prior to the government. Irreversible changes. Then B. Article 3 and 36 recognize the irreversible changes actions in this case. Both sovereignty and reoperationalization of Article 970 permitted actions in this proclamation had been reoperationalization of Article 670 is permitted. If the proclamation had been approved by the legislative and non-legislative powers after the proclamation of emergency, the president reserves both legislative and non-legislative powers after the proclamation of emergency 356. The former does not 356 any powers of Article the Union Parliament or the President. The former does not relate any power of the state on the Union Parliament or the President. Dealt with the challenge to Section 3 and 4 of the Jammu and Kashmir Reorganization Act. Now dealt with the challenge to Section 3 and 4 of the Jammu and Kashmir Reorganization Act on the touchstone of Article 3. The challenge to Section required debate on the Reorganization Act on behalf of the Government of India is not required to debate on account be restored on behalf of the Government of India. B. That it is imperative to ascertain the views restored 10 days later under the first proviso to Article. It is imperative to ascertain the views will affect the area bounded the first proviso to Article. However, in the instance case, if the proposed state of Jammu and Kashmir area bounded the name route, the state however in the instance was already dissolved. Since state of Jammu and Kashmir was under legislature were performed by the Union Parliament was already dissolved. Hence, it was not possible functions of the state legislature were performed by the Union Parliament. Follows that Section 3 of the reorganization to ascertain the views of the state legislature. It follows that Section 3 of the reorganization at the end of the judgment. Well, I have pen down an epilogue at the end of the judgment. The Valley of Kashmir carries a historical burden. Maybe some sentiment, a social context. The Valley of Kashmir carries a historical burden to the region. It has a social context to segregate the aforesaid. In involving we the people of Jammu and Kashmir are difficult to segregate the aforesaid. We the people of Jammu and Kashmir victims of conflict for several decades. Originating from 1947, carried the burden of the victims of conflict for several decades. Intervening originating from 1947 did not permit a redressal to the fullest extent. Intervening political circumstances, the consequences remain not permit a redressal to the fullest extent occupied by other
seeking the
countries.
concurrence of the union government, instead of the government of the state to seek CO2 70 is not invalid because, first, the effect of applying all the provisions of the constitution to the state of Jammu and Kashmir through the exercise of power under Article 171D is the same as an exercise of power under Article 370, Clause 3, notifying that Article 370 shall cease to exist. That is, all provisions of the Constitution of India will apply to the state of Jammu and Kashmir, except for the fact that the former can be reversed, while the latter, namely under Clause 3, cannot. Second, consultation and collaboration between both the unions will only be necessary with the application of the provisions of the Indian Constitution in the state would require amendments
in their endeavor to preserve women and children of the state of the state a heavy price. Against foreign incursions. During my travels home over the years, women and children of the state have paid a heavy price. And during my travels home over the years, trauma absorbed the already social society. And I cannot help but feel anguished about the trauma of the region already fractured society. And I am constrained to write. I cannot help but feel anguished about the people of the region have experienced. The wounds need healing. To write this. What is at stake is not simply preventing the recurrence of injustice. The wounds need healing. But the burden of restoring the region's social fabric, preventing the recurrence of injustice historically has been. But the burden of restoring the region's social fabric and mutual respect. What it's historically. It is worth noting that even the partition of India in 1947 did not impair Jammu and Kashmir communal and social harmony. In this context, Mahatma Gandhi is famously quoted to communal and social harmony. Kashmir was a ray of hope. In this context, Mahatma Gandhi is famously quoted to achieve a collective Kashmir was a ray of hope for human rights violations. The first step perpetuated both by state and non-state actors against the people of violations. There have been numerous reports documenting these incidents over the years. People of this region. Yet, what is lacking is a commonly accepted narrative of what has over the years. Or in other words, what is lacking is a commonly accepted narrative of what is the right of victims. Or in other words, a collective telling of the end itself. Internationally, the right of victims of human rights violations, events, and social political structures. It encompasses the structural investigation of particular circumstances and social political structures that led to the authoritative reporting of the results of circumstances of individual suffering. Truth-telling provides an opportunity for victims to narrate their stories, which facilitates an acknowledgement provides an opportunity for victims to narrate their stories, and from the society as a whole. From this paves the way for reconciliating the wrong, while there are different society as a whole. These objectives. This paves the way for reconciliation commissions have been while there are different ways of achieving these objectives. South Africa Truth and Reconciliation Commission particularly was set up to investigate human rights violations. South Africa Truth and Reconciliation Commission was set up to investigate as a mean of reckoning perpetuated during the period of apartheid regime and fostered peace building. It served as a mean of reflecting on its success for victims and fostered peace building. As a result of the TRC on its private sorrow in L.B. Sachs notice was publicly as a result of the TRC to an embracing and personalized way. Another form of acknowledgement emerged from perpetrators to an embracing and personalized way. To come forward openly in front of the television cameras perpetrators themselves. Finally, to come forward openly in front of the television camera, these things that happen and can happen. Finally, again, acknowledgement that we needed to fit all these things that happen together can happen in some kind of significant that we needed to fit would enable us to understand their genesis and in some kind of significant minimize any which would enable us to understand their genesis. In the past, what we could do to minimize any possibility of their recurrence have also been in the past, different sections of the valley. Truth and in view of the inroads have also been globally echoed by different sections of the valley for truth and amendments to the state constitution because the purpose of the requirements of consultation and collaboration is for the smooth functioning of governance in the state and to ensure that the provisions of the Constitution of Jammu and Kashmir are not inconsistent with the provisions of the Constitution of India. The Commission we hold that the President seeking the concurrence of the Union government instead of the government of the state to CO2 72 is not invalid because the effect
effect of applying all the provisions of the Constitution
to them that we hold the greatest
we hold
involved.
that the President seeking the concurrence of the Union government instead of the government of the state to issue CO272 is not invalid because first,
the challenges of
the effect of applying all the provisions of the Constitution
beyond the realm
to the state of Jammu and Kashmir through the exercise of power under Article
beyond the realm of the
371D
are facets
is the same as an exercise of power under Article 370 Clause 3, notifying that Article 370 shall cease to exist. That is, all provisions of the Constitution of India will apply to the state of Jammu and Kashmir, except for the fact that the former can be reversed while the latter, namely under Clause 3, cannot. Second,
it is this context that the Constitution is no different and is designed to ensure that courts offer justice in situations and is where fundamental rights have been violated. Courts offer justice historic situations. Our courts have been fundamental rights have been violated of our polity. Doing justice and have offered flexible remedies. Have been sensitive to the social demands of our polity of Rajasthan and have offered flexible guidelines to address the workplace and others versus the state of Rajasthan enacted law. This court issued guidelines under the Parliament enacted the sexual in the absence of an enacted law, which operates the word of Parliament and a Commission once constituted of Women's Act should not turn into a criminal court. As the word of caution, follow the Commission humanized in a personalized process should not turn into enabling a criminal court to share what they have been through humanized in a personalized process. It should be based on a dialogue to share what they have been through uninhibited from all sides. It should be based on a dialogue allowing for different viewpoints and inputs from all sides. In this context of judges do not cry, Archbishop Tutu cried. Elbe Sachs court of law in the sense judges do not cry. Archbishop Tutu cried. Highly formalized findings. It was not a court of law in the sense of an austere, intensely institution making a highly formalized findings. There to hear was an appropriately dignified setting up what people had been there to hear. There were comforters sitting dignified setting up what people court of law, no one is there. There were comforters sitting next to the shoulder or provide water. Court of law, no one is there to help the witness. Frequently, the sessions would start shoulder or provide water African harmony. Intended to give a sense of encouragement and support to everybody present. African harmony, or it could begin intended to give a sense of encouragement and support to everybody present in all regions, or it could begin with the prayers. And therefore, the testimony was televised, and thus the nation became witness. All languages, what has happened and heard, the testimony was televised from the mouths of the person. Thus, the nation became witness. Those who spoke happened and not complainants directly from the mouths of persons in the dock. Those who spoke were not were the litigants demanding damages for themselves. Persons so that the greater the loss, the greater were the litigants demanding damages for themselves. Taking a leaf out of the greater the loss, the principle
indicates that a gradual process of constitutional integration was ongoing. The declaration issued by the President under Article 370 Clause 3 is a culmination of the
enabled central to the process. For the wounds of the past, facilitate a reparative approach achieving that shared national identity. For the wounds of the past, and the Commission is only one of the many
seeking the concurrence of the Union government instead of the government of the state to issue CO272 is not invalid because first, the effect of applying all the provisions of the Constitution to the state of Jammu and Kashmir through the exercise of power under Article 371D is the same as an exercise of power under Article 370 Clause 3, notifying that Article 370 shall cease to exist. That is, all provisions of the Constitution of India will apply to the state of Jammu and Kashmir, except for the fact that the former can be reversed while the latter, namely under Clause 3, cannot. Second, consultation and collaboration between both the units will only be necessary where the application of the provisions of the Indian Constitution to the state would require amendments to the state constitution because the purpose of the requirements of we hold that the President seeking the concurrence of the Union government instead of the government of the state to issue CO272 is not invalid because first, the effect of applying all the provisions of the Constitution to the state of Jammu and Kashmir through the exercise of power under Article 371D is the same as an exercise of power
enacted as legislative provision and did not have Article 370 was an abrogation of Article 370 does not negate the federal structure. As citizens, the abrogation of Article 370 does not negate the federal and will enjoy the same status and rights living in Jammu and Kashmir do and will enjoy the same status and rights as given paragraph 2 of CO 270 residing in other parts of by which Article 370 was paragraph 2 of CO course to Article 367 by which Article 370 was amended by taking recourse to Article it can be sustained in view of corresponding powers in bad and under Article 371 it can be sustained more important corresponding Article 370 has been made inoperative in terms of more importantly to Article 370 has been made inoperative in terms of clause 373 to Article 370. I have agreed with what Justice Chandrachud has said. Chief Justice has said with regard to Article 356 of the Constitution of India. I have also made reference to Article 356 of the Constitution of India and others. I have also made reference to Rameshwar Prasad. I also agree with the conclusions recorded by Dr. with which I respectfully agree. I also agree with the conclusions taking record of the statement made on behalf of E.Y. Chandrachud for restoration of the statement record of the statement made on Jammu and Kashmir while upholding for restoration of the statement of Ladakh of Jammu and Kashmir. I have agreed with Justice Call with regard to interpretation Ladakh on Article 370. I have agreed with Justice Call with regard to interpretation on Article 370 Clause 3.
So we are going to have 7 temples here. In this area, just outside Parkota, there will be separate temples, not together. 7 separate temples will be built. कि इस पूरे स्ट्रक्चर में
आजकल खांसी सुनते
आयरन कहीं
सब पीछे पड़ जाते हैं, पर ये
क्योंकि आयरन की लाइफ जो है वो
झंडू आयुर्वेदिक कफ सिरप 10 में से 9 लोगों ने माना है
हम तो 1000 इयर्स का टेंपल बना रहे हैं. 3500
झंडू आयुर्वेदिक कफ सिरप पहले डोज से असर दिखाए.
Day and night. So we are going to have 7 temples. My generation, even your generation, younger generation. In this area, just outside many generations who have gone, there will be separate temples. They never not ever together. Thought 7 separate temples will be a reality. Not a single pie has come from any government agency for the construction of the temple. The first Land Acquisition Act. It was implemented with the advice, aid and advice of ministers and myself. But the beauty of this Prime Minister day and night. And I went to tell him that please do not issue the third ordinance, younger generation. He looked at me. He said, and many generations who have gone, they never ever thought, you guys are that the